case number C200262, John Yeager et al. Versus U.S. Bank as trustee of Sarah Lee Yeager Trust. If counsel for the appellant can please identify themselves and their readiness to proceed.
Good morning, Your Honors. Nick Zuccarelli. I'm the counsel for the appellants, and I am ready to proceed whenever you are.
Okay. And counsel for the appellee, if you can please identify yourself and your readiness to proceed.
Good morning, Your Honors. My name is Anna Grieve. I represent the appellee, U.S. Bank, ready to proceed.
Okay. Attorney Zuccarelli, would you like to reserve time?
Sure, if I could reserve 3 minutes for rebuttal.
All righty. Whenever you're ready.
Okay, thank you. Good morning, Your Honors. As mentioned, I'm Nick Zuccarelli, and I'm counsel for the appellants John Yeager, Steve Yeager, and Mike Yeager, here today on appeal of an order granting objections to a magistrate's decision, which thereby granted appellee U.S. Bank as trustees motion to dismiss a complaint. Wanted to start with a very brief background of the facts in this case. The trust was formed in 1990 by
Mr. Zuccarelli, was the trust agreement ever placed in the record? Because I've looked for it and can't find it, and it says it's attached to your amended complaint.
That I'd have to check the trial court dockets and see if it was attached. It very rightfully should have been attached to the amended complaint, certainly.
Because I think there's a problem in understanding what the structure of this trust is, because the complaint itself is pretty bare bones in terms of details. Okay. So when you talk about the interest of the beneficiary, it's like we don't have context based on the complaint, because the complaint doesn't explain what the beneficiary's interest is. Sure,
understood. I mean, as a 10,000-foot view, which is the best I can do orally here without, physically providing you a copy of the trust. The trust was set up by a grantor in 1990, Sarah Yeager, and then it was a generation skipping trust. It provided for income distributions to her son, Robert Yeager, during his lifetime. And then after that, it went to the grantor's grandchildren, which are the appellants in this case. So they had
and I think generally those facts are pled in the complaint.
Okay. So I will not waste your time by reiterating facts that you're already aware of then.
Well, I think what you shared with us is within the record.
Okay.
Regardless of whether the trust itself is attached to the complaint. Okay.
So kind of pressing forward then, the factual basis that gave rise to this case was in 2011, which was after the initial grantor died. Sarah Lee Yeager died in 2004. Robert Yeager was the current beneficiary, and my clients, the appellants, were then future beneficiaries with a vested interest because the original grantor had died. In 2011, it was discovered that U.S. Bank's trust officer had been embezzling from the trust. Reimbursement was made in 2011 of about $450,000. I think it was a little bit north of $450,000. And the trust account statements just say miscellaneous reimbursement for cash due to loss. Not much information provided to my clients. So when they became current beneficiaries in 2017, they first became aware of this issue when they reviewed the account statements from 2011. They sent a letter to the trustee demanding an accounting, and the trustee declined to provide that accounting, which gave rise to this case. So really distilled down, this is a case of statutory interpretation. The question that we're asking the court to decide is this: does revised code 5808.13a empower current beneficiaries of a trust to compel an accounting from a time after the trust became irrevocable, but before the present beneficiaries became current? We would answer this question.
The appellees seem to cite the Lewis case. How do you distinguish that?
Yeah, I'd be happy to. The Lewis case was a situation in which the beneficiaries were seeking information about the trust from a time before it became irrevocable. So this gave rise to the court's discussion of standing in that case. And I do have a quote from that case available. I just need to find it here. The Lewis court, they denied them information relating to accounting from the time before they became current beneficiaries. In reaching this holding, the court said, because all of their interests were subject to complete divestment while the grantor was still alive, we hold that neither the Lewis, complainant in that case, nor the Lewis children were in privity with the grantor or the alleged wrongdoers and could not sue for mistakes arising from pre-death advice. Again, in this case, we are
So
talking about.
in the Lewis case, were they beneficiaries at all? Were they
They were beneficiaries without.
under the statute? In other words, were they vested? Let me put it like this: were they vested beneficiaries?
They were not vested beneficiaries
Yeah,
because.
the statute gives rights to vested beneficiaries, doesn't it?
Correct. And
So
that
I should have asked the question differently, and I said whether they were beneficiaries at all.
That's
Under the
okay.
statute, it differentiates between vested and current.
It differentiates between beneficiaries and future beneficiaries, but the case law distinguishes that and says only vested beneficiaries have rights to order an accounting. If you've got an inter vivos trust, and you say I'm leaving something to my grandchildren, well, those grandchildren can't compel an accounting from a time when the grantor is still alive, because the grantor tomorrow could say I'm amending this trust and cutting those grandchildren out, and now they've got an accounting for a trust that they have no interest in. But once the grantor dies, as we had in 2004 in this case, that's when the interest vests. And that's why my clients had a vested interest in 2011 when this alleged embezzlement occurred.
Back on the Lewis case, I mean, it's talking about privity, but I'm just not convinced that's the right concept here. I mean, privity we usually think about in terms of a contractual relationship, or certainly if there's a lawyer-client relationship. But here, I mean, is the issue just who has a duty and when?
I believe who has a duty and when. If you could explain that a little bit more, so I answer your question.
Well, I mean, I guess I'm not convinced that Lewis is correct in terms of its focus on privity. Usually we look at it a tort claim, who has a duty and was that duty breached? And I'm just curious as to your view on, is privity the right concept, or should we simplify it and be more duty focused?
Well, I don't know if there's a distinguishment in the question you're asking between vesting and privity. I think they're using privity in shorthand to say, you are something of a party to a contract when you have a vested interest. And yes, and at that moment, I think when your interest vests, in the case of a trust, when the grantor dies, then a duty is owed by the trustee to all beneficiaries with a vested interest to keep them reasonably informed about the material facts necessary to protect their interest in the trust. And in this case, if the trustee can't provide that accounting, then they're violating the duty to provide that information to my clients.
Isn't part of this defining what is a current beneficiary? Is a current beneficiary only the first level of beneficiaries, or can it be later beneficiaries?
Right, and I'm glad that you asked this question, because that was the first assignment of error and the first statutory interpretation issue that I wanted to discuss, and that was 580813A says that current beneficiaries, who I do believe are only, look, between 2004 when the grantor died, 2017 when Robert Eager died, Robert Eager was the only current beneficiary of the trust. But then in 2017, my clients became current beneficiaries, as they were presently entitled to income distributions and other benefits of the trust. But that statute says that current beneficiaries are entitled to all material information necessary to protect their interest in the trust. It doesn't add in a limitation that they're only entitled to material information from the time they became current beneficiaries. And that's really where the genesis of this case lies, is that the trustee's argument is that they're not entitled to any information before 2017 because that's when they became beneficiaries.
Well, doesn't the first part of the statute give it, in essence, a duty to the trustee to keep the current beneficiaries informed?
Yes, it does.
And so is that the part that you're speaking to, or are you speaking to the second part of the statute that says that the trustee will promptly respond to a beneficiary's request of information related to the administration of the trust.
I don't think that these two sentences of the statute can really be divided and interpreted entirely separately. I think that the statute should be interpreted as a whole. But if I had to choose one of those two, I would say that we are talking about the first sentence. This is a current beneficiary's right to compel information about material facts necessary for them to protect their interest in the trust. And again, it's just that the limitation is only current beneficiaries have this power. The limitation is not, and they only have it with regard to time after they became current beneficiaries.
For clarity, is it your position that the second sentence, that the use of beneficiary is intended to apply to current beneficiaries?
I believe that both of these terms, current beneficiaries and beneficiaries, are defined under 5808. And the second sentence grants rights to all beneficiaries, future and current.
Okay.
But in this case, I don't even need to extend that far because the Yeagers, my Yeagers, my clients, the Yeagers, made this request at a time when they were current beneficiaries. So both sentences of 5808(1)(3)(a)
Right. Because
empower them.
there's two things that in your complaint that you basically assert, and one is that the trustee had a duty to provide, to keep them informed, and I don't know if that was pursuant to the first sentence, but right? And then the other thing that you asserted was that that the trustee had failed to respond to the beneficiary's request regarding it. They were asking for accounting, and you were, in essence, under information related to the administration of the trust. So there were two things that you were asserting against the trustee. One was the duty to provide this reporting, and the other one was the duty to respond to the request.
Yes, Your Honor. Yeah. So I do believe that one of those, there is a duty of the trustee to do this, whether there's a request made or not, to keep the beneficiaries reasonably informed about the trust administration. And also,
So to that point, doesn't the statute as to keeping the beneficiaries informed, doesn't that apply to current beneficiaries? And then how would that apply to your clients?
well, yes, indeed, it does apply to current beneficiaries. I understand that.
So are you asserting that once they became current, the trustee was not providing these reports? Or are you asserting before they became current beneficiaries, the trustee should have been providing the reports?
No, I think that the trustee should have provided reports when they became current beneficiaries. But when they became current beneficiaries, they also affirmatively requested this information.
Okay.
And when the trustee, declined to provide that, that was the second violation of their duty under 5808(13).
Okay. So I guess that's what the clarity that I needed to have. So in the complaint, what you were in essence saying was that since they became current beneficiaries, these reports were not being provided by the trustee?
Were not being provided by the trustee on their own or in response to the request that the current beneficiaries made.
Okay, thank you.
Which was, if I'm being honest, the more egregious of the two violations was my clients affirmatively stated, there's this mysterious $450,000 flick of the wrist, wave of the hand saying, oh, well, that makes all the embezzlement better. And we need more information about that. I'd like to know.
I understand that, but I think there's a distinction between that aspect of this case and then the affirmative claims for recovery, because I just don't understand how you can make a legitimate claim for damages without that information. Because, for instance, let's say that the embezzler took $200,000 and the next month they reimbursed $400,000 just to make everybody happy and go away. Then your clients haven't been damaged at all. In fact, they've been benefited. So, I realize your predicament, whereas you don't know because you don't have the information. But how can you conceivably claim damages at this point without that information?
Well, I think you hit the nail on the head. It's very difficult for us to put into hard numbers exactly what our damages are, because.
Or even that you've been damaged. Like
Well,
your clients might not have been damaged at all.
Right. Now, we do have to assume in a motion to dismiss that the allegations of the complaint are taken as true. But it's when the trustee obfuscates this information.
But sorry to keep harping on this, but you haven't alleged that US Bank deposited less than the amount necessary to make your clients whole.
Right, and we haven't been able to do that because the trustee has refused to provide any information about the embezzlement of its own trust officer.
Right.
Right, and so that is further, I think, a convincing argument that we are entitled to that information. Otherwise, that statute becomes, basically toothless. We can't have the information we need to pursue claims, which very rightfully might be there. It rewards the trustee for obfuscating information and setting up roadblocks. That
But
can't
you're claiming that they may have embezzled $1 million and only replaced 450,000.
That's right. They may have embezzled more. They may not have taken factors into account that they should have taken. Maybe it was $453,000 of principal that was taken out of the trust. But if the reimbursement was made 10 years later, was interest accounted for? There was a number of things that maybe should have been put into that calculation that we don't know at this point because we can't have that information. And
Counsel,
it
thank
is-
you. I'm going to reserve your 3 minutes.
Sure.
No, thank you.
Thank you.
Good morning.
Good morning, Your Honors, and may it please the court. The question at issue today is what Ohio's trust code requires of trustees. U.S. Bank has complied with the trust code, but the Yeagers are asking for something more, for this court to expand a trustee's duty beyond what is required from the plain text of the relevant statutes.
Ms. Grieve, let me ask you a question. Let's say that the primary beneficiary or the only current beneficiary has Alzheimer's. And you as the trustee, you have a rogue employee who is embezzling funds from that account. The beneficiary doesn't know because they're essentially incompetent. And then that beneficiary dies, and then the contingent beneficiaries come in and say, well, we want to get information about that account, and you say no because you don't have a right to it. You weren't a current beneficiary at the time. So how does the fraud in that circumstance ever get uncovered if you're correct?
Your Honor, that is a different situation than what we have here because of the then current beneficiary, Robert Yeager. Now, the Yeagers never alleged that Robert Yeager could not or did not adequately protect the trust.
No. I understand. I understand it's different. But my point is the rule of law that you're advocating would apply in the circumstance I just described and would be wielded by untoward actors to prevent future beneficiaries from learning of their fraud if we agree with you. And I'm just trying to understand how we reconcile those points.
Your Honor, respectfully, I disagree. I don't think the interpretation we're advocating for would require that result because of specific language in 5808.13. I'll call it 0.13 for short. Now, the first sentence of 0.13, which appellant recognizes that they're requesting under discusses information, quote, necessary for them to protect their interest. Now, in the situation Your Honors described, the later current beneficiaries are in a different situation because the then current beneficiary wasn't in a position to protect the interest of the trust. So in that situation, and Your Honor's hypothetical, you have an argument that because the then current beneficiary couldn't protect the trust, well, now they need this information. Now they need the material facts necessary for them to protect the trust. We don't have that here because we don't have a then current beneficiary who was infirm in any way. Now, in their amended complaint, the Yeagers never alleged that Robert Yeager was infirm. They never alleged that he did not adequately protect the trust, and they never alleged that he could not adequately protect the trust. That means that even though they say they're under that first sentence in 0.13, they don't actually allege that they need material facts necessary for them to protect their interest because Robert Yeager protected the trust interest.
Well, how did they know that without, access to the settlement agreement.
Your Honor, that's a deficiency in their complaint. They could have pleaded that Robert Eager was unable to protect the trust. They did not do so. And because a motion to dismiss is considered on the four corners of the complaint, that's a serious omission in their complaint here.
But how
No.
would they know anything with regard to this? Because as I understand, it was after Robert Eager had passed that the now current beneficiaries were aware of what had occurred.
Yes, Your Honor, I understand that
And
the
and they
current
only know it
Eagers,
pursuant to the depositing of this check. That's the only information they have is the depositing of the check. And
Yes, Your
the
Honor.
notation within the check.
Sorry, Your Honor, I'm not sure I understand the question.
Well, they don't come to find out until they are apprised of that this check had been deposited and are apprised of the notation that's on the check. And they don't, as I understand, it wasn't until after Robert Eager passed that they had learned that this check had deposited, which then, the request ensued thereafter.
Yes, Your Honor, I understand that to be how they pleaded in the complaint, but regardless.
So to your point, your thing is like, hey, they should have pled that Robert Eager was not protecting the trust. I don't know how they can get there if all they know is a check was deposited from US Bank into the trust. There's a notation and there's embezzlement that had taken place.
Well, Your Honor, those allegations don't necessarily require knowledge of the underlying settlement agreement. They presumably had interactions with Robert Eager and they knew, things like that. But again, we could talk all day about things they could have pled in their complaint to make this sufficient. At the end of the day, as Judge Bergeron said, this is a pretty bare bones complaint. Now,
Do you know, is the trust agreement in the record? Do you know?
No, Your Honor, it is not, arguably in violation of Civil Rule 10D.
What if the bank had embezzled $1 million and then told Mr. Yeager Sr., oh, don't worry, we're replacing the $453,000 that was embezzled. And he just accepted that. And wouldn't it be appropriate for the new beneficiaries to ask to check into that?
Your Honor, that's not how the Ohio Trust Code has set up. Now, consider the real practical problems with the Yeager's argument. Now, they focus on 2011, but under their theory, they would be entitled to an accounting for any event happening during any time Robert Eager was a current beneficiary. In the early 1990s, if the death of the settler had happened then.
Well, but I guess I don't see really what the problem is with that. I mean, you're the trustee, you are obligated to keep records and provide the beneficiaries with information. Yes, it may be burdensome for the trustee to go back and find the records from a while back, but they should maintain those anyway. So I guess I don't really see what the problem is. And frankly, I don't understand why the bank wouldn't be forthcoming with the beneficiaries in this circumstance.
Your Honor, of course, U.S. Bank makes every effort to comply with the Trust Code, but the question at issue today, and this won't affect just U.S. Bank, this is about what obligations are put on trustees all across Ohio as a result of the Trust Code, not just about in this particular case. Now, Your Honors, again, of course, as I mentioned, there are practical problems with the Yeager's interpretation. Even under their interpretation, what if their children became beneficiaries 5, 10, 20 years from now? Under their interpretation, this reaches back infinitely, meaning they are asking you to read limitations that the General Assembly put into the statute out of it. That cannot be the right way to read a statute. Now, the General Assembly used the phrase current beneficiary in the first sentence of 0.13, and so it must have done so for a reason. Now, Your Honors, furthermore,
but what about the second sentence that says beneficiaries, unless, I don't have it in front of me, but unless the request is unreasonable, the trustee shall provide information to beneficiaries?
Your Honor, there is a key difference between the first and the second sentence in 0.13 that I think is helpful to illustrate the question that you're asking. Now, the first sentence refers to information, quote, about the administration of the trust and of the material facts necessary for them to protect their interest, end quote. Now, the second sentence refers only to, quote, information related to the administration of the trust. So that second sentence has removed that material facts language from the first part of the sentence. But the Yeagers pleaded in their amended complaint, paragraph 18 specifically, they're asking for material, they acknowledge they're under the first sentence in point 1.3. So, but they cannot be because they were not current beneficiaries of the trust in 2011. And of course, appellants now argue that, well, yes, we weren't current beneficiaries then, but we are now. So now we're entitled to that information. Well, again, that's simply reading a limitation in the statute out of existence. Now, Your Honors, I'd like to touch on the Yeagers, or excuse me, one more point on point 1.3. Now, the Yeagers focus on point 1.3a specifically, but point 1.3a doesn't actually provide for an accounting at all. Now, Judge Zayas, you talked about this reporting requirements, and that's actually discussed in point 1.3c, which is not discussed one time, not in their complaint, and not at any point in their brief. Now, under point 1.3c, a trustee of a trust shall send certain information, including a report of the trust property, liabilities, receipts and disbursements, etc. There is no allegation that the Yeagers never received the information required under point 1.3c. Now, for the first time in oral argument, attorney for appellants says now that, yes, we're saying that you didn't provide us those reports, but that's not how their complaint reads. Their complaint says, we asked for an accounting based on events in 2011, and we did not get that information. There is no allegation in their complaint that they did not receive the required reports under point 1.3c. Now, in fact, the one case that the Yeagers cite in support of their substantive argument in Ray Fair and Trust doesn't even deal with point 1.3a. It deals with point 1.3c. And the fact that the Yeagers don't cite this statute and don't rely on it shows that they know they would lose under this argument. Your Honors, one more point on point 1.3c. I'd point you to the official comment to the trust code, which says, the duty articulated in subsection A would ordinarily be satisfied by providing the beneficiary with a copy of the annual report mandated in subsection C. Again, there's no allegation that U.S. Bank ever failed to provide information required under subsection C.
Let me ask you the question about privity that I inartfully asked your opposing counsel. Is this, you all moved and said they can't bring these claims because there's no privity, but is privity even the right concept? I mean, these aren't contractual claims. These aren't claims based on representation by counsel. These are kind of garden variety common law tort claims. So is privity the right concept?
Well, Your Honor, actually, so you discussed Lewis versus Star Bank. Another case that the appellants cite in their brief, Peleg v. Spitz, talks about this a little differently in terms of standing. So I acknowledge that courts have discussed this a little bit differently, but regardless of the label you put on it, the underlying principle stands that people who were not current beneficiaries at certain points in time cannot retroactively gain the rights that then current beneficiaries have. In fact, Your Honor, in the reply brief, appellants cited Peleg versus Spitz for the proposition that interest vested upon the death of the settler. But even in Peleg, the court there still said that the plaintiffs did not have standing to sue based on the fact that based on what their interests were at the time of the alleged wrongdoing. Now, Your Honors, you had asked, or excuse me, Judge Bergeron, you had asked earlier about duty. Is duty the right way to articulate this? Well, arguably, the only duty isn't really discussed. So, excuse me, appellants brought five
and
claims.
maybe to give you a little bit more guidance, does a trustee of a trust have a fiduciary duty to future beneficiaries?
Well, Your Honor, I don't think that's anything that, well, arguably, the Yeagers have actually abandoned their claim for fiduciary duty on appeal. Even though it was discussed below, they don't discuss it once in their reply brief. And certainly, and actually, regardless of whether a trustee has a duty to a future beneficiary, the Yeagers here have never alleged that U.S. Bank breached any fiduciary duty. They acknowledge that it was a rogue employee of U.S. Bank who committed this alleged embezzlement. But the Yeagers fail to acknowledge that U.S. Bank isn't liable for the intentional torts of its employees unless it's under a limited exception, such as the employee acting at the direction of the employer or acting for the benefit of the employer. And again, there's a dearth of any allegation of anything like that in their complaints. Now, Your Honors, there are
Counsel,
really
you have about a minute.
Thank you, Your Honor. Your Honors, there are really two independent problems with the Yeager's argument here. First is the privity or standing requirement, or however you want to phrase it. Simply put, under Ohio's precedent, the Yeagers cannot sue based on events that occurred in 2011 before they were then current beneficiaries. That's only one problem with their argument. There is a second independent problem with their arguments, because what they're asking for under the Ohio Trust Code under .13 isn't there. They're asking you to read limitations out of the statute and to ignore words to get the results they want. At the end of the day, this, as Judge Bergeron said, is a bare bones complaint. But Ohio courts have said that unsupported conclusions of a complaint are not taken as admitted and are not sufficient to withstand a motion to dismiss. Your Honors, for all of these reasons, we would ask that you affirm the result of the trial court dismissing the amended complaints. Thank you.
Thank you. Counsel, you still have your 3 minutes.
Thank you very much. I will try to be brief even within the 3 minutes. With all due respect to the opposing counsel, I heard a lot of discussion about then current beneficiaries. I mean, that's an example of what I was talking about, reading limitations into the statute that just aren't there. The statute doesn't say that then current beneficiaries are entitled to information about time after which they became current beneficiaries. It says when you're a current beneficiary, as the Yeagers were when they made the request for an accounting, you're entitled to information necessary to protect your interests in the trust. We don't need to complicate that or muddy the waters any more than that. Current beneficiaries are entitled to information that they need to protect their interest in the trust. That kind of segued during the previous period into, it didn't quite understand the argument about Robert Yeager could have protected their interests in the trust. My clients weren't involved in the settlement discussions. They didn't sign off on the settlement agreement, which, the trustee has since abandoned its argument that that's enforceable. That was incumbent upon the trustee to bring in future beneficiaries. They knew that. They knew the statutes. U.S. Bank is a sophisticated trustee. They didn't involve my clients in those discussions, and that's what landed us here today. If they had been involved back in 2011, there would have been full disclosure of all this information before my clients signed off on any agreement resolving claims. And if that disclosure hadn't happened, my clients would have asserted the claims at that time. There was some discussion about, it might be ridiculous if, current beneficiaries are entitled to information about any time since they had a vested interest. Well, yes, I appreciate Judge Bergeron's asking the question, what's wrong with that? Why is that an undesirable outcome that from the time of the grantor's passing in 2004, when my clients had a concrete vested interest in this trust, until 2018, the time that they made this request, that they're entitled to information about that period? That makes perfect sense to me. I don't think that is by any stretch an absurd result.
And counsel, I have a question. Today, Appelli has argued that because the trust was not attached to the complaint, that was sufficient for dismissal. Have they argued that prior to today's argument?
They have not argued that, and thank you for bringing this up. They have not argued that prior. It was not in the motion to dismiss. It was not part of the claims from which the appeal was made. It was not part of the entry dismissing, overruling the magistrate's, granting the magistrate's objections and dismissing the case. That's the first time this has been brought up. It's plainly, while I do understand that having that in the court record is maybe something that's desirable and should have been done, it's simply not what we're here reviewing today. It's not the issues of law that were briefed at the trial court level or at the appellate court level. There was a little bit more discussion as well about 5808.13c, which is
Counsel,
a right.
That leaves you about 30 seconds.
Thank you. In that case, I won't launch into a new diatribe. Just thank you for your time this morning. I say that I think in the interest of justice and ensuring that beneficiaries are allowed to protect their rights in a trust and to be kept informed and to prevent rewarding trustees from obfuscating their own wrongdoing. In this case, the trustee's own trust officer embezzling, and then the trustee throwing a whole bunch of smoke and mirrors out there and saying, no, you're not allowed to see any information about what happened. We can't reward that kind of behavior. That's just unacceptable in the interest of justice and the law. And for that reason, I hope that you will reverse the trial court's decision and grant my clients the relief they seek. Thank you.
Thank you both for your arguments this morning. We will take the matter into submission and issue a timely decision, and we wish you a wonderful afternoon.
Thank you so much, everybody.